Thank you very much, Jorge, for the introduction to our today's webinar, which is mainly dealing with legal considerations for enterprise websites. What are you about to expect? So we go into key legal consideration for especially enterprise websites, because we know that in an enterprise context, you may have to deal with more abroad legislation throughout countries, because you provide your website throughout different countries in different languages where maybe different privacy laws might apply. We go through navigating through GDPR and data privacy compliance, where I will soon and in a minute introduce you our today's guest. And we touch intellectual property issues as well. We cover some Q&A. And it's a practical webinar, and we try to get it to the point with an average duration of roughly 40 to 45 minutes. So who we are, let's first get a brief introduction, and I welcome very warmly our today's guest, Dr. Andreas Spüttgerber, who is our lawyer and partner lawyer from Reed Smith, and I'm happy to give him a mic for some minutes of its own introduction, if possible.
Yeah, thanks, Alexander, for this nice introduction, for having me, and hello, everyone. Yeah, I'm not a medical doctor, but a legal doctor. So I can help you cure your website and be legally compliant on the website. Mainly, we'll have a focus on German laws and European laws today. I'm a partner at the law firm Reed Smith. I'm based in Munich in Germany, and I'm head of our technology and data protection practice in Germany. I'm also global head of our AI practice. I'm doing this already for quite a long time, and we're advising companies on all sorts of technology, data protection, data, and AI and digitalization questions. One main focus that has been occupying me throughout my career are really websites and apps and how to make them compliant. Every organization has a website and an app, and it's the business card of the organization. It's very easy for competitors, for authorities and others to look at it and to find mistakes or incompliances. So this is always one of the first items we help startups and also grown-up companies or companies that enter into the German or European market to get compliant with their website, to have this outside-facing portfolio and presentation in a compliant manner. So yeah, looking forward to helping you a bit today and giving you some tips how to do that. Back to you, Alexander. Thanks.
Great. Thank you very much, Andreas. Yeah, some words about me. I'm Alexander. I'm the CEO and co-founder of TWIPLA, which is the abbreviation for the Website Intelligence Platform. We mainly deal with website statistics, all being driven privacy first. That's why Andy, Andreas, and we know each other for, I think, nearly a decade, and we have profited a lot from your knowledge, being a legal doctor, not a medical one. And we are happy to dive and delve into this topic of e-privacy and GDPR, and assumingly, this is what we usually trying to implement, that the European laws, especially the German law, is so strict. So if you make it in Germany, then you can make it in Europe, and most likely you will also make it throughout the rest of the world. So I'm happy that we are gathered together today here, and then let's jump into our brief introduction. So I already gave some brief introduction about who we are. So TWIPLA is established since back in 2015. We are started as a very small and tiny Wix app in the back then newly launched Wix app market. We have collected more than 2.5 million installed websites since then. And we're very proud of collecting more and thousands of 5-star reviews throughout the well-known platforms like G2 or Crosstex, or even when you look at the reviews at the Wix app market. So we are available on all platforms, but that's today. It should not be a sales presentation, as we want to purely deal on all these legal issues. And then I might hand over back to Andreas again, maybe that he can give a bit more brief introduction of his role and his focuses. And I would now hand over the mic to you again in terms of delving into all of these privacy and legal issues.
Yeah, thank you very much. Yeah, so let's have a look. Your organization is now planning to have a website that is addressing German and potentially also European users. So what are the main legal obligations that you have to consider and bear in mind? First of all, of course, there is data protection topics. That's all about handling of personal data. That is information that identifies an individual. You have in this context also the famous cookie rules, and we'll speak a bit more about that today, of course. You have certain transparency obligations towards consumers and generally also to B2B users. The most famous one in Germany is the Impressum, the legal notice. You have this obligation in a few countries in Europe, but not many. And Germans are special lovers of the legal notice. That is basically basic company information on name, address, CEO, contact details for the organization. The background for this is basically that if there are any issues with website compliance or the website, users can contact the company. So this is a very important aspect. Every website needs to have that. And it's, as I said in the beginning, it's very easy for competitors. And there's always people who don't like you or your organizations to bring this to court, to send a cease and desist letter. And this causes not only cost and efforts, but only reputation potentially. So bear this in mind. The legal notice is really extremely important. Every website needs to have this. Every website. We'll come to the privacy topics in detail later, but every website also needs to have a privacy policy where it is explained what personal data is being handled on this website. Then the other item that you always need to have in mind is IP, intellectual property. So all content you put on the website, your organizations must have the rights to do this. So mainly photos, pictures, but also text that is copied from otherwhere or that is created with ChatGPT or other AI tools. You always need to make sure there are sufficient rights, and not only to use the content, but to publish the content. That's the rule, that's the right you must have, or your organization must have, to place content on the website. So these are the three most important legal topics you must have in mind when you set up your website. In the IP topic, perhaps also consider trademarks. Especially trademarks on the URLs or on the address of the website you're choosing. These are the three most important ones. Now, if you add other functionalities to your website, additional legal obligations will apply. For example, you have a newsletter subscription service. You must check that your newsletter consent wording complies with the spamming laws in Europe or Germany. If you have a shop or a registered area, you need to make sure you have clear terms and conditions about what the users are getting when they sign up. In the shop, there are special obligations, not only B2C, but also B2B on distance selling, so selling over the internet. There must be special information be provided to the customers. Very new in Europe, and laws are kicking in this summer, are accessibility obligations. So like a standard information website does not have to comply with this, but websites that have an e-commerce shop or that advertise for e-commerce shops, they have to meet certain accessibility requirements so that users that are disabled have also access to the website, for example, by hearing content. by getting it read, or other means for disabled persons to access the information on the website. So that's just coming up this year. Not many companies have implemented this yet. Other topics on additional functionalities we see very often are embedded content. If your organization embeds, for example, YouTube videos or social media buttons, this is mostly a question of transparency. So make transparent that this is not your own content, but third-party platform content. And then often there's also a data transfer to this third party, which needs to be explained to the user. So bear in mind the three first categories I mentioned. So privacy, imprint or legal notice, and IP. And then bear in mind any additional functionality that is being added to your website might also have to meet additional requirements. And this is where you have to closely work with legal team, data protection, marketing. So we often see that marketing then adds functionalities and legal team doesn't know. So that's important to talk to each other right at the beginning and the planning status. With this overview, let's have a bit of a closer look into the data protection topics that come up on a website. So basically, the website needs to have the permission to process, that means to collect, to store, to use information that is relating to an individual. And so that is clearly is a name, it's an email address. So when you're operating only information website, you might say, well, I don't have this, but yes, you do, because your server is getting technical information on at least an IP address, likely also device IDs, the timestamp of visit, the user journey. This is all considered personal information. And in the end, the organization must check, okay, which information are we getting? What purpose are we using this information for? Are we permitted to do this? There are certain justification criteria under GDPR. You all know the consent, of course, but some data processing is also possible because it's just technically necessary, or because the user wants to, for example, order the newsletter. Then you have to process the email address. And this step has to be performed for each purpose. Yeah. One purpose being, for example, providing the website, one purpose being IT security, website security, one purpose being providing newsletter service, one purpose being contact us function, and so on. So you have to check that and then inform the user in a privacy policy about all this. So that's the famous privacy policy. That's very important. If you're using IT service providers to operate your website, you have to also explain this in your privacy policy, and you have to make sure you have sufficient data protection agreements with these providers. That's also very important. But most of the providers today have those as a standard and in a pretty good shape. So usually this is not too much of a problem with the providers. Then there is this second data protection related topic, e-privacy. There has been discussion around the e-privacy regulation in the past years, similar to GDPR, but this was abandoned now. So e-privacy regulation is not coming. The European Commission has communicated this beginning of this year. But there is still the old e-privacy directive that is now nearly 20 years old. And basically, it provides for rules on so-called cookies. It's a bit broader. We always say it's a cookie directive, but it says basically that if a company is storing information on an end user device or accessing information that is already stored on an end user device, then the organization must collect consent unless there is a very narrow room for exemptions from this consent requirement. So again, when you plan your website, you have to check, okay, which functionality, which tool that I'm using is either writing information on the user device. So a cookie is, storing, writing information that's fulfilled. But also other functionalities, other like a pixel or information that is being accessed. So in an app, very often the app pulls information from the user device. This falls also under this category. So again, you need to check the functionalities. What are they exactly doing? What data is being pulled? And here it's important, it must not only be personal data, it can be any information. So these e-privacy rules are broader than data protection rules. And then it needs to be assessed, do I need consent? Yes or no? If you need consent, then the famous cookie banner needs to be put in place, and the users must get the option to opt in or not opt in into cookies. So that's GDPR e-privacy on the website. Let's also have a closer look into the IP topics I mentioned already at the beginning. Text, photos, videos, logos, so that's copyright, trademarks. So you need to check again for every content you're uploading and using, whether you have the sufficient licenses. Usually when you license in your content, you can check in the license agreement for which purposes you may use it. We now lately see more difficulties with AI generated content because you often don't get like an explicit license agreement with the content you're getting from your AI tool. So basically it is rather a no, don't use content from available AI tools that is being created unless you're really sure that the tool provides you with the license to upload the content to your website. Many organizations at the moment use AI as like an idea creator and then create their own content from this. This is then usually no IP problem. So that's the thing to do here. Check the licensing agreement. Be careful with AI generated content, and you hear this very often float around, the words fair use. That comes from the US copyright system, but Europe knows a similar principle that for certain, for example, academic purposes or for citations, if you're discussing a certain article and you're citing this article and discuss this, then it is permitted to use this content without a specific license, but the scope is rather narrow in Europe, I would say. So with this, I think we've given you a good toolbox to check on these important items on the website. And Alex is now having a closer look with you into the cookie topic and what can be done with analytics there.
Okay, great stuff, Andy. Thank you very much for this really brief introduction about all these aspects of legal loopholes and thresholds regarding to bringing a simple website online for providing services or your products or whatever you do in an enterprise context. I have some spontaneous questions I just wanted to briefly bring up. One of the things is to summarize the meaning of GDPR and e-privacy on a very, very basic level. Can we say that GDPR mainly or solely deals with the fact that you as a website owner are trying to store any kind of information onto the user's device? And on the other hand, The e-privacy aspect is dealing with the fact that you're about to retrieving any information which is already on the device, including, of course, the stuff that you might have written yourself upfront onto the device. Can we say that?
Yeah, I guess yes. I mean, there is no so clear-cut differentiation, and definitely GDPR is about personal data, and e-privacy is about generally information. So that's kind of like the two other differences, but the rest can be used as a good guidance. Yeah.
Great stuff. So this would also cover, if you now have mentioned the part about the personal information about human beings in regards of the GDPR. So this explains more or less the exception about these so-called strictly technical necessary cookies. So if your website provides a login and you enter your details, and this website needs a certain cookie to be set on the user's device to persist and keep the login alive, where there is no personal data involved, this is something why you don't need a consent for putting these technical necessary cookies onto the user's device, correct?
In the result, yes. If you look at authorities, data protection authorities enforcing those types of questions, they do a two-step test. So they first say, is placing of the cookie permitted under e-privacy laws? And the second test is then, is the information we generated from the cookie, may the organization process this under GDPR? And now, if we look at your example, the login memory cookie, the e-privacy test would be, okay, yes, we have a cookie, it's stored, so we're into e-privacy. There, and then I said there are a few exemptions. So one exemption, like you mentioned, is it's necessary to perform the service that has been requested by the user. This is the user wanted to log in, and the login only works with this cookie. So yes, tick the box. We have a necessary cookie. We don't need consent under e-privacy. Now we look at the second step. Okay, which information do we collect with this cookie? I guess IP address, perhaps the username. I don't know if that's stored in the cookie. The session ID probably. So yes, we do have personal data that we're reading as a website. So we need to have a permission to do this. What is our GDPR permission? That's Article 6. I would say performance of a contract, login. We have some sort of contract with the user because they want to use our services. So we need this data to perform this contract with the user. So no consent required. So, in the end, you said no consent. So, right, the authorities do this two-step test, which needs to at least run in the lawyer's head to be sure we're on the safe side.
Okay, I see. So as always, the devil lies in the details, and just saying, okay, a strictly necessary cookies, no consent is sometimes true, sometimes not. So in a broader context, it's always recommended to do some certain consultation about what's exactly been stored in that cookie in order to provide the login and to avoid further implications in legal nature,
Yes.
so to speak.
Yes, as a rule of thumb, if the processing, which usually is the case, of the data is like what's necessary, for the service. So if everything like looks normal, there's no excessive processing, then as a rule of thumb, you can always say if you have a strictly necessary cookie, then the processing of the data is also okay under GDPR. That's the rule of thumb. Usually they go hand in hand.
Okay, great stuff. Cool. I have some more other things I'm pretty curious about because I encountered you mentioned that example by providing a contact form on your website. And what I encountered from time to time is a certain misconception about the purpose of a privacy policy. Some of the websites, or let's say maybe might be half-half, do have this addition to the contact form where you have a last line saying there is an unchecked check mark, which of course is unchecked because this reference to this famous Planet 49 jurisdiction some years ago. But anyway, there is a checkbox which is unchecked and saying, with sending this form, you accept, or I accept, the privacy policy. And people have to check this checkbox in order to be able to send maybe this contact form. And I think the misconception from what I encountered back in the days and all the time is that privacy policy is nothing like a contract, nothing that you have to agree on. It's most likely that you have to notify him without the checkbox saying, by sending, you notified or just had the chance to read our privacy policy. There is no consent, no checkbox to be checked needed in order to send a contact form. Is this correct?
Yes, exactly. It's a mistake to have a checkbox. It can have, you can cause real legal problems. So only information. Yes.
Because you imply this is a contract, which it shouldn't be. It must
exactly.
be.
Yeah.
Got it. Okay, perfect. And regarding that example that you've mentioned regarding this German speciality, also I think it's Switzerland and some other European countries, you mentioned this terms of an imprint and legal notice. Yes, we know that it's very important if you are located as a German company in Germany or all the other countries which have this implication, that a imprint, aka legal notice, is necessary. But there is no harm when you do this as well if you might be located in a country, maybe also in the European Union, where there is no obligation to do so, because it just, in my point, it raises trust that you are transparent. What is the company, where it's located, who's responsible, maybe a possibility to add a contact form. Do you see any disadvantages in adding an imprint, let's say by default, on your website?
No, there is no disadvantage from a legal side. There might be a disadvantage from a practical side, because you open up a communication channel to all users. And so we see organizations get, messages by postal mail or to an email address that has to be indicated, where they don't want, because they prefer to channel their users through a contact form or something. So practically could be disadvantages. Legally, no. Perhaps one aspect, and I wanted to mention in the beginning that you just kind of like indirectly addressed, is the international applicability of all these laws. Just briefly, if you remember the 3 pots I said about privacy, legal notice, and IP. There are different international rules of international applicability of these 3 pots. For GDPR, it is basically, where is your company located? And as a second test, if you're not located in Germany or Europe, are you addressing European or German users? So that's the GDPR test. So if you're based in the US, but you're selling your services, you're offering the website to German users, then your website has to meet GDPR German standards. For the legal notice, the same. If you're addressing German users, no matter where you're located, you have to have a legal notice. And for IP, it is called the country of protection principles. So again, in the country where you're using the IP, you have to have the rights. So again, if your website is accessible and clearly addressing Germany because of German language, or you're accepting payment in Europe, you're delivering, you're sending your products to customers in Germany, and that is clearly making clear you're addressing the German market, then you have to comply also with the IP. So again, as a rule of thumb, the 3 pots are slightly different, but generally, if you're addressing German or European users, you have to comply with these requirements irrespective of where you're located.
Okay, thank you very much. I think this explained why in the beginning, when GDPR came into place, May 2018, we encountered a lot of these geo-blockers from American websites where they were not like saying, no, we don't serve Europeans because we don't want to get in touch with GDPR.
Exactly.
Yeah, over time, this has improved. It was long time announced before, so that there was no surprise. But yeah, these were the measurements. I remember then visiting whatever American websites, and there was a geo-blocking in place. Interesting stuff. But yeah, stuff evolves, and the thing is, if you, let's say, comply with GDPR and e-privacy, especially in a German context, you're, let's say, pretty well settled for being compliant with the rest of the world, because we are famous for our strict laws, as we may have invented this kind of called Datenschutz. Okay, cool. I want to cover maybe three more questions in that regards. Is the main thing, if now you encountered with all your legal investigations, okay, there is no way around to have a cookie banner, to collect, let's say, consents in a summarized way. I think it's very important to look at the provider of your consent banner. And what I also encountered over the last time is that you should ideally bring in balanced buttons. We know all these cookie banners where you have like accept all on the one side and you have reject all on the other side. And I usually perceive this as fair and okay if you have balanced buttons, same size, same color, same font size, and so on, and not tapping into, let's say, so-called dark pattern or nudging, where you make the accept all pretty greenish, very big, and then you have a small, maybe not even a button saying reject all text input. What is your opinion on these approaches?
So my opinion is different than the authorities' opinion.
Okay.
I guess you want to hear the authorities' opinion. Authorities are quite strict in Europe. They want an accept button and a reject button. And they want them in the same size, in the same font, and in many countries in the same color. It depends on the details, but for example, from Austria, we've had cases where they insist on the same coloring. In Germany, we see they're a bit more relaxed on the coloring, as long as kind of like the coloring is not leading the user into one or the other direction. So that's always the question: is the user misled or led to a certain, and then consent? Often it is decision through the color scheme, because it's a color the user likes or feels more attractive or is used to clicking. For example, green. Yeah, put the one green, they consent green and the reject red. You have probably many users clicking the green because they like to click green instead of red.
That means we are not yet having a, let's say, a highly courted decision yet, and authorities do, let's take the role of interpreting the stuff until somebody is really going the hardware. So you also have to geo-target or geo-base your consent banner based on maybe certain rules that might apply and possibility that you have. Because I do understand from an enterprise view of a website owner, of course, I would be very happy if everybody presses accept all, because there might be aligned ad campaigns and other stuff, which win part and turns into pure KPIs that you can gather from that. But on the other side, you have to comply with the law. So we are still in a phase where we are not yet sure what's the right approach throughout whole Europe.
Well, we know we have to have these two buttons. We know they have to be more or less the same size. And I think around the rest, there's room for interpretation. My personal opinion and hope is that we are not getting more case law on this, because it is getting very much into detail. And I also think that users are now used to the cookie banners and used to the boxes, and they pay more attention. So I think it's not like a few years ago when this was all new to users, but they now are aware. So you can also expect that they really read what's there and not only click blindly because of a certain color. So I hope the case law is done now, and we can jump to other topics.
Okay, got it. Yeah, I must admit, I really take the time finding the reject button, if necessary, based on the website. Also doing the same for the accept button, but also related to the website. But yes, some reliability and security on this matter, and not going into that much of a detail would surely simplify all others or everyone's life here. Cool. Last but not least, the thing with the embedded content, very, very interesting, because I'll cover this maybe also, or cover this in my talk, is about the impact of this embedded content. We can agree on that there's literally no service where you can embed content or use third-party tools like we had very prominently some time ago with the Google fonts. The same applies for the Facebook pixel or the Google Ads pixel, or embed YouTube videos or Spotify streams, whatever. There's literally no chance to embed anything which is, let's say, external, without any submission of any personal data, at least the IP address, because the other server needs this part of the HTTP protocol. There is no chance even to, there might be solutions to proxy that, but in general, you have to have a consent if you plan to embed external stuff. Do you agree on that?
Yes. I'm just thinking whether I'm aware of any exemptions, but generally I totally agree. Yes. It might only if the third-party content doesn't drop any cookies and doesn't track and only provides the content, but in practice I don't see this very often or at all.
Yeah, that's exactly my assumption. What could be an exception, in my point of view, if you have a stable data processing agreement with the provider, and he's like working as a sub processor of your own, and you have a stable contractual relationship with them. Then of course you're allowed to do that, because of course you have to check the integrity and all these things, and then you have to have no fear in terms of, is there any personal data being submitted or transferred which the visitor of my website will lose its control of. Okay, or you agree on that? Or if
I agree on this, but be careful. Like, this is not to you, but to the audience, because some like bigger platforms declare their processor, but they're not. So I would say the example you just brought is more really, it's not really embedded content, then it's own content. Yeah, I would consider it more fully controlled own content that is like, perhaps operated or provided by a third party for me. But yeah, I mean, totally right. But everyone has to be careful and not only check the paperwork by the provider, but also check, is this really what we're living in the relationship?
Yeah, makes totally sense. That embedded content would be the wrong phrase for that. But this reminds me a bit in the beginning, and still, if you browse through the internet, I'm not sure whether you encountered this yourself. If you look for privacy compliance, and then the main buzzword is often GDPR ready. Yeah, which is like saying, in my point of view, it says nothing. And if you go dig deeper into that, it's like, yeah, GDPR ready if you doing the hard work for me, because the only thing I want to do is to sell my service. But GDPR ready, somebody told me from marketing, this sounds good and serious, and we have to put it on our website. But yeah, as stated, in all these contexts, legal consultation is always recommended, to not step into any really sometimes pretty expensive mistakes and then fix it afterwards. But the GDPR ready stuff, Andy?
Sure, yeah. Good
I enjoy it a lot. Yes, this is marketing. Okay, last question now, just covering a bit this AI generated content. So I took out of the thing, and what I've read about AI generated content, the main issue is, first of all, that there is no real creator, because it's a machine. So this machine does not have a, let's say, origin right of having a copyright in itself, like we would know from human beings, a painter, a musician, or whatever. And so it cannot grant you maybe a permission to provide or to reuse this content on your website, issue number one. And the second one would be that you could never tell, because all of these AI systems, they are based on trainings and material that have different origins. in order to train the system to generate that stuff that you have requested via prompt. And nobody literally can say for sure that they have not been done any copyright infringements by training these models, issue 2. So to summarize it, the best would be, as you stated already, take this as an inspirational approach and then maybe redraw it yourself. Beside the fact it's better not to put any any AI generated content on your website if you have the possibility to make something of your own out of that what the machine has generated for you. Do you share this approach?
Yes, I do. And I mean, this is heavy content. So like, this legal topic could be like for 1 or 2 own seminars. Yes, that's totally right. And it's also right. And we do have case law in Europe and also in the US confirming that like purely AI generated content does not amount to copyright protection because the human aspect is missing. But as you say, I mean, it's always the question, what's in the training material, perhaps what's in the prompt by the user that is being uploaded. So there are a lot of questions around this, and this is why it is at the moment still very difficult to make a clear legal assessment. We're now getting the European AI Act, or I mean, the European AI Act is already in place, but August 2nd will be a big date when the rules on generative AI kick in. And one of the obligations of providers or developers of generative AI will be to publish in a directory the copyright protected material that has been used for training. That's a pretty hard obligation, but for the user side and for companies deploying AI, this might be helpful in determining the step whether they can use or not use the output, for example, for their website. So still a lot in development, and yeah, watch out for that, I would say.
Yeah, great. Thank you, Andy, very much for these very helpful insights into all of these aspects that you have to consider when launching a, let's say, pretty simple enterprise website, providing your services and offering your products. So now let's maybe jump into more of this aspect of analytics, which is, of course, from our point of view, something very substantial and fundamental. So in our world, every website needs, especially every enterprise website needs analytics, needs stats in order to understand, is there any traction? Do you have visitors? And so on, and keep on improving your website and strengthen and improve these numbers. But what are the benefits? As you might have known, TWIPLA is pretty famous for implementing our service and our product always privacy first. So let's have a deeper look on the benefits of adopting cookieless analytics. As we have learned, if you want to drop a cookie, you need a consent. And most likely, we have seen studies about this adoption of cookie banners and all these opt-in rates. And the results are more or less similar over all these experiences that we have made also with our own enterprise clients within TWIPLA. So we can assume that the opt-in rate is literally, if you do it, let's say right, is around 20, maybe 25%, depending on how you do it. But if you do it right, these are common numbers that we have encountered. So we have asked ourselves and wondered, why do this burden with a cookie banner if you can maybe have something which doesn't imply a cookie, which most likely in the end could also end up in the situation that you don't even need a cookie banner because there might be no other services on your website that imply the usage of a cookie banner. And coming to the issue number one is, of course, we have an increasing privacy and consent regulations in the European Union and, of course, globally. I think the World Privacy Map, if you want to Google that, it shows literally no left unknown blind spots in that area. Even China has launched very comprehensive privacy laws. Of course, the United States, maybe on a state base, you might heard of CCPA, the California Consumer Protection Act, and others. And the other thing which is also increasing is the issue number 2, which is called cookie banner fatigue. That means, of course, you know it's there, you know you have to interact, but yeah, there is either, I also heard of visitors, they just literally neglect cookie banners, so they don't even touch it. So if there's only a spot left to browse the page within the viewport, they just take it as it is. That's granted. They just ignore the cookie banner because they don't want to take a decision, and others just do a search and a hunt for the reject all button, or just work with ad blockers, cookie blockers, and all this stuff, which is also not in the interest of acquiring information. So if your system is dependent on getting these cookies accepted, you either way are really dependent on that, or you might have not found yet a perfect alternative to this. And what's the goal of all these things is that you get maybe 100% of your visible visitors back. So these assumingly allegedly 25% opt-in rate will result that you have a blind spot with the area of 75% of your users. And the other stuff is, of course, if I would ask you, maybe get less data from 100% of your visitors instead of getting maybe everything of 25 or even only 20. I think the decision should be obvious in terms of marketing, engagement, and all the other reach related KPIs that you're about to acquire throughout your analytics tool. So the thing is pretty simple why we have done what we did. Our goal was, and I think Andy can remember that, I think it's some years ago when we had the first chat about it, and Andy and his team was closely engaging us with that idea and this adventure. And I remember it was some years ago when I talked to Andy and say, hey, could you think about a solution where we don't need cookies at all? Is there a possibility to say, let's go something like consentless, which was in the beginning of GDPR was something like, hey, how can that be? Yeah, in the first beginning of GDPR, the overall opinion driven by marketing teams and whatever was that you cannot even launch a website without a cookie banner. So it seems to be a must, which is of course not correct, because with all the helpful informations and insights from Andy, you have learned only if you do these things, which implies a consent, you need a consent. But if you don't do these things, there is no need for a consent. But this was the idea, and our goal was from the very beginning to comply with the strongest laws in the world, which I assume would be at least one of them within Germany, and also with the GDPR and the aligned e-privacy directive. And in this case, we have made it possible to get something up where a consent is, say, obsolete, in the manner of that we do not, let's simplify it, like already said, the main approach that we did, we do not store anything onto the device, and we do not get anything from the device, which implies a consent. And this makes it doable. And all our experience in regards of enterprise clients have shown the same result. If you have started maybe with literally 1 million visitors with your current analytics tool, which reflected these 20%, by going consentless, you have encountered that your real visitors amount was somehow maybe 4 million or 5 million afterwards. By the abolishment of a cookie banner, removing the friction from your website, and going with a tool that respects privacy, is done privacy first, made up in Germany, hosted in Germany, complying with all the laws, and taking all this legal headache from you in order to bring your visitors back into your analytics dashboard. And as stated, the main purpose, and of course it's just a matter of an option that you have, is about removing the cookie banner. But there are also possibilities which we called maybe the hybrid mode. So if you are and if you're forced to use a cookie banner anyway, because you run marketing campaigns and you are happy with only these 20% that you might get a consent from, but nevertheless, you want to have all the insight on all of these 20% by not giving up the cookie banner for the other 100%, we have invented something which is called the hybrid approach, which is fairly simple. You have a cookie banner with 2 buttons where the accept all brings your TWIPLA instance into a, let's say, full access mode, which we also support, of course. of course, related to a consent. And all the other ones, which are, let's say, saying, no, I'm just feeling better with rejecting the cookie banner, they will fall back in our consentless approach, which means you still end up with 100% of your visitors, with the interesting fact that the 20% who have accepted the cookie banner provide you more insights on the data, but you still end up with 100% of your visitors visible finally again, because we have taken that burden from you. And the other part I already mentioned is that we are respecting all these laws, which are globally getting into place. We are, of course, observing the world privacy development very closely in terms of what's coming up, what is happening there, and readjust our approach in order to being compliant on all of these things out of the box. And again, taking the headache from you in order to reassessing all these tools that you use by just saying, okay, I want to go consentless in this certain circumstance, and I want to go, let's say, full access mode when somebody's clicking the accept all button on my cookie banner, which I crucially need for all my marketing activities. So last but not least, I'm very thankful that Dr. Andreas Splittgerber, which is a legal doctor, and I had a question for you. How often have you been confused with a medical doctor and somebody said, where is a doctor? We need some help. Has this ever happened to you?
Yes, every time I travel outside of Germany.
Really? Because
no one understands why one can do a doctor as a lawyer.
Why you don't have a PhD?
Yeah.
Okay, funny stuff. But could you help sometimes from time to time? Like at least being there in as a moral instance, knowingly that
I can treat most illnesses, yes.
Okay, perfect. Very good. So thank you very much, Andy. I hope you learned a lot how either way obeying all these laws, including the possibility to bring the best out of this digital world to your marketing activities and all these analytical and statistical needs to your enterprise websites. And we are happy, very, very happy if you have further questions that you might post in that platform here within the comment section. And we are happy to answer these as soon as possible. If not possible, feel free to send us an email, support@twipla.com, or visit our website and inform yourself about the future of analytics and statistics in a potential consentless world. Andy, thank you very much for your time.
Thank you. It was a pleasure for me talking with you about this topic and hoping to continue the discussion on other topics or related topics.
Yes, I think surely AI is a very big topic. Maybe we can take a chance for a next session and get a bit light in the shed of AI, because I think there are a lot of rumors, misconceptions around. And I'm happy to join you on that session. And thank you very much for your time. Thank you very much, Jorge, for hosting this session. And see you soon, and take care.
Thank you. Thanks. Bye-bye.
Bye.